Hey everyone, welcome back to today's video. We've got 3 solid clips lined up for you, kicking things off in Judge Perkins' courtroom, where an overconfident individual attempts to push a scripted argument, but quickly gets sidelined as the judge prioritizes those who are genuinely present to handle their legal responsibilities. No wasted time, no nonsense, just order, authority, and real accountability. Let's get started.
I need Destiny Gray. This is the City of Detroit, Mr. Berry versus Destiny Graves, case number SB16, strike that, SB10699059, counts 1 and counts 2, SB172478881, SB1724805, counts 1, 2, and 3, and SB1724836. Appearance for the city.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established in the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's me, lowercase ESTINEY, hyphen, capital R, lowercase AIVYN, colon, capital G, lowercase RAVES.
You're standing in a courtroom today, which means personal jurisdiction is already locked in. On top of that, the records show the charges were filed properly, so subject matter jurisdiction is clearly in place as well. In other words, the court has full authority to proceed, the legal foundation is solid, and there's no ambiguity about where things stand or what happens next.
Okay. Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel that jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay. So, I mean, if you can't give me an answer to my question, then I'm going to put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again?
Is this denying my abatement plea?
I'm not getting into this, ma'am.
All right, so Judge Perkins moved right past the issue, making it clear he wasn't interested in recycled talking points or empty theatrics. The individual chose to walk away instead of addressing the court properly, failed to return, and that decision triggered a warrant due to non-compliance. With that resolved, we shift to the next case, someone who isn't pushing a fringe legal theory, but instead follows an extreme personal belief system that rejects legal representation altogether, even when that choice puts their own freedom at serious risk.
No, you're over there.
All right, this is cause number CR 22-368, State of Texas versus Seth Edward Atkins. All right, Mr. Atkins, the state has filed a motion to adjudicate your guilt and to revoke your community supervision. I want to take a moment and display on the screen their allegations before we have a conversation about whether or not you want to proceed and represent yourself. Okay, can you see that on your screen?
Yes, sir. Oh, okay. Can we go back up? Just fine.
Hey, I don't want you to say anything. I just want you to read.
Okay. Yes, sir. Yes, sir.
All right, so Mr. Atkins, I don't want you to say anything other than to answer my questions that are going to be limited to the discussion of whether or not you want to represent yourself. Now, that's been indicated to me by Ms. Tabraham in your own words without telling me anything about these allegations or your case, why it is that you want to represent yourself.
I don't really trust lawyers anymore, and I'm more than qualified to represent myself, Mr. Martin.
I can understand being cautious about lawyers, but refusing professional help when your freedom is on the line is no different than rejecting a medical specialist for a critical condition and trying to handle it yourself. It's a risky move that trades expertise for misplaced confidence, often with serious consequences.
Good book says that they're bought and paid for. Bought and paid for, man.
The good book being the what
The whole
book?
company. The whole company.
And where does it say in the Bible that attorneys are bought and paid for?
Jesus had a whole conversation with a lawyer who searched after his own righteousness and showed him the way.
And Jesus in the red word said to be weary of lawyers because they're bought and paid.
Don't trust them.
It says don't, and where does it say that?
Do you want me to get it for you?
Yes.
Mark, can you please look up which verses? I know it's in Matthew and John, but I want the good one where Jesus has the conversation with the lawyer. Thank you, Mr. Flynn.
You have to be careful not to take person's
Oh, I know. It's all about just seeking after your own righteousness and how all sin is evil. This Bible, right? It's not just in the Hebrew Bible?
It's quite a few verses.
It's a bunch of them. I don't know if King James and the Council of Nicaea decided to take out that part or not.
Sorry, Mr. Martin.
Okay, take your time.
Yes, sir. I'm sorry for all of this. I really am.
Okay, take your time. Find the verse, find the scripture that So you decided to.
Not in the way that, you know, it's not in the way that all of them are bought and paid for, but I know how bureaucracy works, and
Well, I don't want to get too far from what you said earlier. You said that the Bible says, that God's word says, do not trust lawyers because they are bought and paid for. I
you know,
want
it's because the law, men of the law search after their own righteousness.
no, sir, sir, no, sir. You said that that's what the Bible says, and that's one of your grounds for why you want to represent yourself. You read to me the book of the Bible, the verse, the chapter, and I want to know if it's Jesus's words or if it's someone else.
Yes.
And if you don't find that and that's not in there, then you come back and you tell me it's not in there.
Yes.
And move on to the next one. But I don't want to move into talking about self-righteousness and bureaucracy. So go ahead and sit down and read through the Bible and tell me where it's at and tell me when you're ready.
I consider it too bad.
Hey, Your Honor.
Go ahead, Mr. Atkins.
Okay. So the verse has been taken out of this Bible. In the Hebrew Bible, it's in there. I know where it's at. If I had my scrolls and stuff, I could show you.
Where are those at?
Obviously, that reference points to the Dead Sea region, and while I'm not especially religious myself, the meaning here is pretty clear. In the Hebrew Bible, specifically Isaiah 10:1-2, there's a strong warning against those who create unjust rules and misuse authority to deny fairness, exploit the vulnerable, and corrupt justice itself. At that point in history, the modern role of legal advocates didn't even exist, so the passage isn't an attack on legal professionals, it's a direct condemnation of corrupt leadership and distorted judgment. The message is about accountability and fairness, not rejecting lawful counsel or the justice system altogether.
So if you want to give me a court-appointed attorney, then go ahead. Please, sir.
Do you want a court-appointed attorney?
I just want y'all's help to fix all this. But yes, I would.
Okay.
I would like a
Well,
court-appointed.
you told my coordinator there that you wanted to represent yourself, and you do have a constitutional right to represent yourself. However, as the judge, it's my job to ensure that you are adequately warned about the dangers of doing so. And so I wanted to give you an opportunity to tell me why you wanted to represent yourself. And obviously, that's the first thing that you've said to me is that you have a religious belief that that Christ said not to trust lawyers because they're bought and paid for. If you can't prove that to me, then we can go on and we can talk about your other points. We can talk about your education, we can talk about your legal training, talk about your familiarity with the rules of criminal procedure. We talk about the advantages, the disadvantages. We talk about your rights. We can have that discussion. I have no problem with it, but I want you to be heard first. And then it's going to be my opportunity to evaluate whether or not I think that it's appropriate for you to have a court-appointed attorney or rather to represent yourself. If you insist on representing yourself, then I will do my job and I will go through the threat of warnings and I'll weigh that. I'll make that decision. If you're telling me that you have a natural distrust of lawyers, okay, that's fine. But you understand, Mr. Atkins, though, that even if an attorney is appointed to you, you make the decisions on what you want to do, whether you want to play true to something, play not true to something. You and you alone get to make that decision. No attorney gets to substitute their decision for your decision. So you are in control. The attorney works for you and helps you to understand the law, helps you understand the weight of the evidence, it helps you understand how to make an informed decision based on the allegations against you. Now, we find that you're indigent and that you are eligible for court-appointed counsel. If you want court-appointed counsel, that attorney will be appointed to you, and then you can discuss the case with them, and then they come and obviously they make the arguments before the court, and they are your representative in court. And at this point, you have an opportunity to have one of two things. You can either negotiate some kind of agreement to resolve the accusations, or you can request to have a hearing in which the state of Texas through their prosecutors will be, they'll bear the burden of proving the truthfulness of the accusations beyond the preponderance of the evidence. It's a lower burden because it is a revocation and it's not a trial on beyond a reasonable doubt. And if they approve that, then you could be revoked and sentenced anywhere from minimum 2 years up to 10 years in prison and a fine not to exceed $10,000. Some of these things I know that you're already aware of because we had this discussion before you were placed on 10 years of deferred adjudication. So if your position is you want to represent yourself, then let's carry on. We'll talk more about it. If it's not, that you do want the assistance of counsel, then let me appoint you an attorney and then let's carry on.
Can I just ask you a question, Judge Martin?
You can, but I don't want you to say anything that could be used against you in court. Okay?
Okay.
All right, go ahead.
I'm not one to let people just keep pushing me around. You know what I mean? Like, I do freak out. I do lose my cool sometimes, but it's never been without justification. You know what I mean? Like my grandmother's husband pulled a gun on me. I got aggravated assault charges behind it, all because he still to this day bullies my Down syndrome uncle, who hates living over there now. And I can't be there to protect him because of him. You know what I mean? And try to tell y'all that you pulled a gun on me. My grandma told y'all she pulled a gun on me. Nothing ever happened. Got picked up on this charge. Someone tried to steal my truck, hit me over the head with a bat to where I'm bleeding down my head. No one even bats an eye. Doesn't ask any questions about who hit me, why they were trying to steal my truck, whether or not I want to press charges. I've always had y'all's back and y'all never had mine.
Careful what you're saying is drifting dangerously close to being turned against you and making an already serious legal situation even worse. Letting emotion drive your decisions right now is exactly why refusing help is such a bad move, because this is the moment when clarity and protection matter most. A court-appointed attorney has one objective and nothing to gain personally, except safeguarding your rights, controlling the damage, and reducing the consequences you're facing. Walking away from that support doesn't prove strength or principle. It only increases the risk when the stakes couldn't be higher.
Jackins, there's nothing in the motion to adjudicate about new charges, about an assault. There's nothing in there. It says that you didn't show up to probation, you didn't pay your fees, you didn't do your community service, you didn't take a class. It has nothing to do with any of the things that you've mentioned. Okay. So at this point, to resolve those, if you have evidence that rebuts that or mitigates that, then that's where we have to get to in the process. And the only way to do that is either represent yourself with the court's permission or have an attorney that works on your behalf that you give information to, and they argue to the court how you're not legally liable for these charges, or that they should be mitigated because of your circumstances in life. That's what we're trying to get to. Obviously, today is not going to be a resolution. Today's not the resolution. Today's not the hearing for that. Today is what we call a pretrial type hearing. And so the only issue before you and me right now, Mr. Atkins, is who's going to represent you. Is it you, or is it going to be an attorney that I appoint to represent you? And I just need to know, if I appoint an attorney, are you going to work with them and do your best and let them represent you, or are you going to be difficult and grieve them and file complaints and make accusations?
I've never given y'all problems like that, Mr. Martin.
I'm not saying you have, Mr. Atkins. I'm not saying you have, but I'm just saying I have to ask that question, because if you believe that there's a religious conviction that you should not accept the help and assistance of an attorney, that may be an underlying motive for you to not work well with an attorney. So I like to know these things going in. And of course, I've been in this position many, many times. And so I've learned over the years to ask these questions because I've seen this become an issue with people in the past, and I just need to know if that's going to be you, then let's don't talk about having an attorney. Let's talk about representing yourself, and if you're going to be able to do so intentionally and knowingly, that you're forewarned on the disadvantages of self-representation.
No, I guess. Will you please appoint me an attorney?
Now that's the first genuinely smart thing you've said this entire hearing. Yes, do that. This is the moment where sense finally cuts through the noise, and choosing the right step forward can make all the difference.
I will do that. So, Ms. Taberham, do you need any paperwork from Mr. Atkins?
He's not completed the affidavit, but
Go ahead and have him complete the application.
okay.
I think I already know what the finding is going to be, but we do need this for our compliance with state law. So fill out the affidavit of indigency, request for court appointed counsel. Let us review that. If you meet the qualifications, and I'm pretty confident you will, then the court will appoint you an attorney. I believe in your underlying case, you were represented by Mr. Jeff White. Is that correct? And I believe, I think I remember that's someone that your family members hired for you. Is that correct?
Paper out of my money, but yes, sir.
All right. Do you have money to hire an attorney?
No, when I went to prison, I gave my mom the rest of the money that I had. She blew it.
All right, then just go ahead and fill out the paperwork, and then let Ms. Taberham tell me where we stand on our appointment process. Okay.
Sure.
All right, you can go ahead and have a seat. You don't have to stand.
All right, that wraps up that hearing, and hopefully for his own good, he steps back from rigid thinking and moves forward with some perspective, because there's nothing in scripture that condemns accepting lawful help to protect your freedom. Now, before we head into the final case, it's worth highlighting the judge presiding over it, Judge Joe Rossi. The last time I covered him, I looked into his background. Retired U.S. Marine Corps Lieutenant Colonel, combat veteran of Desert Storm, former Special Operations instructor, and later an assistant U.S. attorney in the Western District of Michigan. In short, he brings discipline, experience, and deep respect for the rule of law, qualities earned through decades of service. Like all veterans, he commands respect. And it's going to be interesting to see how someone with that level of authority and resolve handles the next individual who challenges the system without understanding it.
And we are just ready to jump straight into our civils.
Yep, and I've got Preferred Credit Union versus Franthia Price next. Is that all right?
Yep.
We are here in the case of Preferred Credit Union versus Franthia Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or imply legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthia.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakikuo, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court. Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Baccucchio, this is not your motion. This is Ms. Price's motion.
Well, that's a striking contradiction. She claims the court has no authority over the very appeal she personally filed in that same courtroom. It's a position that collapses under its own logic, requiring an impressive level of mental gymnastics to deny jurisdiction while actively invoking it. And it highlights just how far some people will stretch reasoning to avoid accountability when facts no longer support their argument.
As to what the relief she's seeking here. I'm prepared to assert preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that, initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular Number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which
Let
collectively...
me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So,
Okay.
Your Honor, may I respond?
Yeah, go ahead, Mr. Baccucchio.
A couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case. So any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthea Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per, but...
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
Okay, whatever that means, Your Honor, this is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Well, she's clearly spent years doubling down on poor judgment, so in her mind, even decades of courtroom experience somehow don't measure up today. It's the kind of misplaced confidence that ignores expertise, dismisses reality, and pretends long-earned knowledge is irrelevant when it doesn't support a failing narrative.
Let me just pause you for a minute, Mr. Bakuko. Something I did see that I did recognize as I paged through the file was the affidavit of transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak,
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record, that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of a contract as well.
When you accepted the credit card, actively used it, and then chose to dodge responsibility instead of honoring the obligation, you weren't making a statement, you were creating a problem. That decision wasn't clever or principled. It was a deliberate choice to enjoy the benefits while rejecting the accountability that comes with them. And that kind of selective logic never holds up when facts, records, and responsibility are brought into the spotlight.